Last night it was alluded to that the appeals were, of course, in effect, that they were going to happen, and we were informed that there would be a good possibility that we would be sued individually if that did happen.
Individually?
No one said that last night.
No,
That was
people
not
were
said.
pointing fingers and saying we would sue the village.
Okay, because there's a difference between
Yeah.
suing the village. The woman who just corrected you, for example, I have seen point at least one town board with a finger that might, and say she personally was going to sue the board members personally. So that's why I'm asking whether they said it personally or just Stephanie.
That we felt that.
She can correct me if that's wrong, but she's
It
not.
is
We
wrong.
felt we
She's
had
been pretty
zoning,
noisy the whole time, she's not correcting me now. Personal
It is wrong, I said.
we had
I
zoning
didn't.
ordinances in place that we felt that they would, if the Dryden case was overturned, wouldn't hold for protecting our particular area. So if the Dryden case was turned over in Mayfield, would we still have our zoning rights we have right now?
Yeah, and if he said that, that is wrong as a matter of law. So I want to know if he said that. I'd be surprised if he said that. But the moratorium, he was probably talking about if you went to the next step. We haven't talked about what you do in a moratorium. A moratorium can't be done just to have a moratorium and you sit on your hands. You have to do something with the period. And the duration we talked about, which has to be reasonable, depends on what you're going to do. What people typically do is they will use the time to focus on road protection schemes. They will use the time to look at their zoning code to see whether or not the zoning code protects them, and if it doesn't, whether or not changes have to be made to the zoning code. I've got a whole presentation here about the sort of things we look at when we look at a zoning code. About
Air, water, and things of that.
well,
nature?
more fundamental than that. You probably have most zoning codes, most well-drafted zoning codes, say or intend to say the only uses in our town, our village, I'm going to say town, so I work with a lot more towns. The only uses in our village that are allowed, either as of right or by special use or whatever, are those that are specifically articulated in the use table. Or the section, what I call use table is the section that says in a residential 2 you can do this, in a commercial 3 you can do that. That's what I mean by use table. So a good zoning ordinance says the only thing you can do in our town is whatever we say you can do, whether it's by special permit or as of right, in the zoning code. Okay, you with me so far? But the problem is, there are a lot of provisions in most zoning codes. Most zoning codes were done a long time before anybody anticipated fracking. So they might have something like mining in it, and it might say in this kind of district you can do mining, either as of right or with a special permit. When your village council passed that ordinance that said mining was okay, what they meant, I promise you, was sand and gravel mining, or maybe topsoil. Okay, they did not mean high volume, slick water, horizontal frack. They couldn't have, because okay? So we go through and we look through it, we find every single one of those, and where it says mining, we do an amendment, and we say, provided, however, that mining shall not mean, be, or include, basically fracking. And we even look at uses that, articulated uses that you wouldn't think are problematic. For example, many people's definition of public utilities is, what most people mean when they say public utility is a company that's a monopoly whose rates are set by the Public Service Commission. But depending on what a particular zoning code might say, it might admit of the possibility that we've seen them where it's so loosey-goosey that it admits of the possibility that you can end up with a compressor station in a residential neighborhood. So anyway, that's what we do. So he could not possibly have said the first part of what he's saying unless he's already read your zoning code. Now what we do as the second part of what we do,
He did review the zoning.
you read the whole zoning code?
Yes.
Okay.
I sent it. He requested it and I sent it.
Okay, well, then what you want, this is very good, then what you want is a legal opinion from him. The way the world works with law firms is with legal opinions. So it doesn't do you one, if he's wrong about that, it doesn't do you, you want a written legal opinion from him that even without a moratorium, that there can't be, by special permit, by anything else, you can't bring drilling into this village, or any of the other things you're worried about. And if that's what he gives you, you don't need a moratorium. He won't give you that. Okay? But if he does, that's fine. But if he does, but if you're going to rely on that, you have to have a written opinion. And if he says, I don't know what a written opinion is, he's kidding you. Because that's a lawyer's stock and trade, written opinions. This gentleman's on the board.
I was just
Actually, I'm sorry, you're pointing at me, which I understand, but if you would point to the chair of the planning board, she'll recognize you, even if you're on her board. But go ahead.
his comment about being sued was regarding if the moratorium were arbitrary, and he did bring up the 5 points. You know, they had a reasonable time frame, valid public purpose, and so on. And that, you know, if those weren't followed, then we'd be vulnerable to that.
He's right,
That's
he's right.
what he's-
Any law that you pass, this is in a different presentation that I do, any law that you pass, whether it's an animal control law, whatever it is, the legal the legal standard is arbitrary and capricious. If you can't be arbitrary and capricious. That, by the way, which he probably didn't bother to tell you, is arbitrary and capricious is the very lowest legal standard that the law recognizes. You satisfying arbitrary and capricious is like falling off a truck, okay? All you have to do to satisfy arbitrary and capricious is you don't have to be clairvoyant, as I showed. You just there has to be a reasonable connection or nexus between what you're worried about and your fix. So if you were worried about fracking and you passed a law that said you can't have hot air balloons in town, there's no connection. But if you're worried about fracking, so you do this, it's not arbitrary and capricious. And by the way, if you decide to do something like this, and you use our law, and I'll put this in writing if you decide to go there, we will absolutely defend you for free on an arbitrary and capricious claim. And if you don't want us, because we're not experienced litigators, we'll try to find you ahead of time experienced litigators to do the same thing. A first-year lawyer can defend on arbitrary and capricious. If the best he's got is arbitrary and capricious, bring it on.
One of the things that I found when talking to people in the village is that people are concerned about water. But I think one of the things that Mr. Wedlake said last night, that he just has built-in protections about water.
The yes guys. The yes guys, a lot of people believe, and I'm sure he believes, that the yes guys has built-in protections for water. The more famous ones, or infamous for those of us who live in upstate New York, including those of us who have unfiltered water, is the fact that the New York City watershed is supposedly off limits based on the yes guys. I think that's a 3-year, so let me keep going. The Syracuse watershed is off limits. That's Skinny Atlas. That's a law we did for them. They weren't relying on it, and they're Skinny Atlas, the town of Skinny Atlas. Most big lakes and most big water bodies have these that are essentially setbacks. What he probably forgot to tell you is that when you go into the S-Geist and look at every single one of those, whether we're talking about the New York City watershed, whether we're talking about the Syracuse watershed, whether we're talking for the limited protections for the various other water bodies, and this is what I'm telling you is not hard to find, by the way. In each case where that appears, every single case, within 2 sentences most, it will make it very clear to you that that protection to which he referred is temporary in nature. It's either 1, 2, or 3 years. The New York City watershed protection is 3 years. Most of the other ones are 1 year. It specifically said they're going to reevaluate it at the end of that time. Now, they didn't put that in there so that they can say we're going to reevaluate it and make it permanent. They put that in there because the industry didn't want them to take anything off limits, even the watersheds and even the water bodies. So they said, so the political fix in that thing was temporary, we'll review, and the idea is if everything's perfect and there's no mistakes, then they'll be able to say, well, nothing happened, we're gonna open it. But every single one, including the New York City watershed, is between 1 and 3 years, it's temporary only. Find one that's not, I will resign my position, I'll fire myself, you know, if he, okay? So he's either mistaken or misleading you.
I was told that in Rome, New York, they have recently banned fracking, and the way they did it was they used police power. Have you heard anything like that?
Well, I know about police power, based where in towns that, I thought you were going somewhere else.
Okay.
Police power, remember I talked about, is the authority. So you got two sources of authority. You've got the statutory town law, village law, city law that specifically gives you zoning or land use power. Then you've got municipal home rule law that confirms, if you will, by statute, that you've got this police power authority. It exists anyway, generally. And again, that's the authority that every municipality has to enact laws to protect the health, safety, and welfare of the people in the municipality and the property. So in towns that have zoning, if we were doing something like this, we would normally rely on, not always, but we normally rely on zoning power. In towns, or both, in towns that don't have zoning, it doesn't apply to you guys. Since you don't have that zoning authority, you use the police power-based authority. So that's how we do laws in places that don't have it. What I think they're talking about is a different kind of law. They're talking about, they got bigger fish to fry with what they're doing. They are basically doing, they're doing corporate rights, essentially. And I don't know if people know about that. There's an entity which isn't us. And one of the reasons, by the way, that people keep asking us about Park, and yes, we take money from Park, and we're grateful for it, and we're honored by it, and we're proud of it. There are people in this room who give us money. We're honored by that and proud of it. But there's an entity that gets a lot more money from Park than we do. And they sound like us. And they're called CELDEF. We're CEDC. It's called CELDEF. Community Environmental Legal Defense Fund. Somebody last night actually suggested that CELDEF funnels money to us. Inaccurate, only out of respect for the person who said it, why not call it nonsense? But if anybody else had said it than him, I would say it's absolute nonsense. But it's untrue. But CELDEF is a Pennsylvania-based public interest law firm. And their whole deal, they're not fracking. They like to say, you don't have a fracking problem, you have a democracy problem. So they go to places like, and I think they're in Rome, and what they're doing, using the police power authority, they pass basically corporate rights ordinances. And those ordinances basically say, you know, corporations can't do anything in our town. They can't, in fact, in those towns, their ordinances will let people frack, although people can't because they don't have the money. But they don't let corporations do anything. So I think, and the legal authority for that is the police power-based authority. So I'm pretty sure that what that person was getting to was a CELDEF, which is not us. And when you go and you look at the Park Foundation, even though I said this repeatedly to other people on the other side, the money that goes to CELDEF is not us. We are CEDC, not CELDF. But that's what CELDEF does. They did one in Buffalo, like
Trying to go against the Supreme Court.
Any other questions for any of our elected officials? No? Okay. Oh, sorry, John.
Is there onerous amounts of paperwork that our paid staff will have to partake in if we enact a moratorium?
No. Well, not in the enactment. The enactment, we would get that to you in a place that has zoning. Before your lawyer gets it, it's 9 pages, which is, I don't think, onerous. A properly drafted moratorium, whether or not it has anything to do with gas drilling, should have a use variance provision. So in places that have zoning like you guys do, we piggyback the use variance right off the existing. So, you know, if you didn't have zoning, it would be a longer. Now, The reason I backed off from saying no is, remember I said you gotta do something with the moratorium. Once you pass that moratorium, then you're gonna, what most people do is they'll have committees. You might have a committee that is, you know, you're on the village board, right? So you might have some people from the planning board, you might have, you should, hope, I'm not telling you what you should do, but typically you have citizens, various other committees in town, and those people are gonna have to do some homework, whether we're talking about road protection schemes, whether we're talking, sometimes people use this to map aquifers this time, sometimes people do critical environmental areas, sometimes people, usually, people do zoning amendments. Now, the zoning amendment is what most people do. I'm really surprised he had time to read the zoning, because what most people do is they have, to do the zoning correctly, you have to read every single page, every single definition rigorously to look for things. I can show you, if you're interested, in another presentation how we do this. What most places do is they have us do that first, no matter what they think of their own lawyer, because that is so time intensive. And then you might boot us, you might say work with our lawyer, but instead of having your lawyer do that, because you don't want to pay him or her by the hour, that takes a long, long time to do that right.
Yeah, this 2-year thing, we shouldn't have to pay any taxes for 2 years, right?
We have another question from.
What 2 years?
planning.
As far as the drive-in and the Middlefield case, how long did it take them to amend the zone in those two situations? Roughly.
Well, Middlefield, as I said, was a couple months, but we had done this. We've done them all over. You know, it could be done. You still would need to do a moratorium. You couldn't do it without a moratorium. We did, because what we're doing is we're basically putting moratoriums in effect for people to put protection in, and then going back to the people who want to do the permanent. But depending on how, you have your zoning code here, depending on how thick your zoning code is, you know, we could, you know, it'd have to go into a queue, but if we did it, you know, we could get it to you, you're at the back of the queue, frankly, on that. You wouldn't get a moratorium. But after that, any kind of zoning amendment, politically, usually takes a while, because everybody wants a piece of the apple, and well, what about this? It's not like you're doing a real change where we're gonna have building heights go from 35 feet to 32 feet, and everybody comes, the developers come out of there. You're not doing that kind of thing. You could do it, including the time that we got it to you, if you used us, you could get it passed within 3 months. And I can give you names of people all around the state that we've done that for. Many of whom, by the way, have asked us, we've done that for them just on the gas bill, and they've come back and asked us to help with their entire zoning code because they were so happy with the quality of the work. Somebody's, by the way, said that villages, it's unusual to do this. The most recent one we did, which is in one of the 5 counties, the village of Owego passed one of these recently. That was ours. So we've done villages, cities, and towns.
Mr. Cummings, did you have your question answered?
8-year engagements aren't long enough, I take it. A lot of people want a 20-year engagement to make up their minds whether they can go with this thing.
I don't know what you mean. I know you're making fun of me, but I really don't get it.
We've been 8 years or so already.
Well, that's a misnomer.
It's like courting a girl, and you can't make up your mind.
I guess I. So is it your view, sir, there's a moratorium in effect right now?
Pardon?
Is it your view that there is a moratorium in effect right now?
I don't go with that, no.
Okay.
I got my mind made up. I've
Okay.
been cordial for
All right.
10, 15 years.
Just so everybody knows.